everyone, welcome to the legal world of Unacademy. I am back with another movie for you. This time, the movie is Section 375, and we are going to learn about the rape laws in India in a comprehensive manner. My name is Tanvi Singh, and I am your Unacademy clad educator. I have pursued my LLB from Symbiosis Law School, Pune, and post that I have worked with various organizations. Also, I have been mentoring students for law exams since last 5 years. If you are interested in attending my Unacademy classes, you can simply refer to the link provided in the description box. You can also join my Telegram channel. The link is there in the description box. And also, if you are interested in the Unacademy subscription, you can avail additional 10% off using my referral code TANVIS10. Let's know a bit about the movie Section 375. The movie portrays a movie director who is accused of raping a costume assistant working on his film. While he is sentenced to jail by the Sessions Court, the case is reopened in High Court, and in the face of media and public scrutiny, two determined lawyers battle it out. The pet dialogue in the movie by the defense counsel is, "We are not in the business of justice, we are in the business of law." I'm not going to spill more beans, but I'll tell you that it's a must-watch movie. It basically presents versions of the same story from two different perspectives, both from the victim's side as well as from the accused side. And along the way, it also it examines the routine procedures, which are a bit disturbing in the way it is shown that it is handled, but that's the grave reality. There is corruption, investigation lapses, which has been portrayed in a gritty, realistic way. As the courtroom drama proceeds, layers keep peeling off. Some facts and some conjectures come to the fore, and joining the dots right till the end. While packing in various standpoints to showcase a balanced view and two sides of the story, the movie also highlights, very important, how media and social media trials take over a criminal case of this nature. Through its intriguing narrative, director Ajay Bal tackles the sensitive issue of rape while throwing light on the abuse of power, dynamics of privilege, and the absolute need for consent, will, and permission when it comes to sex. The movie also spells out points of Section 375 of IPC, and let's learn about the rape laws in India. Under Section 375 of Indian Penal Code, a man is said to commit rape if he does any of the following 5 points. Also, in addition to this, whether he penetrates his penis into the women's vagina, inserts any other object, manipulates any part of women's body, applying his tongue to women's parts, any of the 7 clauses. Also, any of the 7 clauses laid down under 375, which we are going to talk about. So there are 7 clauses which are here. Section 375 says that a man is said to commit rape who, except in the case hereinafter accepted, has sexual intercourse with a woman under circumstances falling under any of the following 6 descriptions. Firstly, against her will. Secondly, without her consent. So, against her will and consent, maybe there is a difference. Will का मतलब होता है that the person is not willing to, बिना उसकी मर्जी से, and consent is the permission, if the permission has been granted or not. So the movie Section 375 also depicts this fact that will is taken above consent. The third point here is that where a man is said to commit rape, with her consent, when her consent has been obtained by putting her or any other person in whom she is interested in fear of death or hurt. Fourthly, with her consent, but when the man knows that he is not her husband, and her consent is given because she believes that he is another man to whom she is or believes her to be lawfully married. Fifthly, with her consent, when, at the time of giving such consent, by reason of unsoundness of mind or intoxication, or the administration by him personally or through another of any stupefying or unwholesome substance, she is unable to understand the nature and consequences of that to which she gives consent. Sixthly, with or without her consent, when she is under 16 years of age. Explanation: penetration is sufficient to constitute the sexual intercourse necessary to the offense of rape. There is one exception over here: sexual intercourse by a man with his own wife. The wife not being under 15 years of age is not rape. Consent. What exactly entails consent? Consent refers to an activity done by a person under a free state of mind. It refers to an act committed by a person by giving assent and approval, giving permission to the other person. Now, according to Section 375, consent can be referred to as an unequivocal voluntary agreement when a woman, by communication, verbal or non-verbal, shows her willingness to commit a specific act. The core concept under consent is choice and not will. To interpret consent, it is necessary to prove, first of all, the person can give consent, and the person with his free choice has accepted the act. Section 375 also talks about consent to intercourse on assumption of false promise to marry. The falsity of promise doesn't ipso facto vitiate consent. It depends whether the accused's promise was false from its inception or not. Now, Section 376 basically provides you the punishment for rape. There are various instances that are provided under Section 376, and it entails the quantum of punishment that will be provided in the circumstances respectively. Now, the offense committed under Section 375 is punished under 376 of IPC is cognizable in nature. A cognizable offense is one in which a police officer under the first schedule or any other legislation in effect can arrest a suspect without a warrant and begin an investigation without the court's consent. Murder, rape, kidnapping, theft, dowry death, and other horrific, serious, grave crimes are examples of cognizable offenses. So, in cases of rape under Section 375, the burden of proof is on the accused. This is in contrast to the principle of the burden being placed on the accused. Eventually, the anti-rape laws strengthened over the decades because of some brutal cases that led to several major amendments in laws. The need for change in laws gathered momentum with the growth of women's movement, which brought about awareness and change in attitude of the society. In this video, we will discuss several cases, namely the Mathura rape case, the Delhi rape case, the Unnao and Kathua rape case, which led to the criminal law amendments of 1983, 2013, and 2018, respectively. It also analyzes the recommendations made by Justice Verma Committee, which was constituted after the Delhi rape case to suggest reforms in the anti-rape laws. It looks closely into the several changes made in the definition and punishments of anti-rape laws. So this video focuses specifically on the changes brought by these amendments in the rape laws under the Indian Penal Code. So Mathura rape case to Delhi rape case. With the escalation of crime over the decades, there have been several amendments in the anti-rape laws. The infamous Mathura case created a nationwide uproar, which eventually led to the Criminal Law Amendment Act of 1983. In the case of Tukaram and others versus State of Maharashtra in 1972, a teenage Adivasi girl named Mathura was alleged to be raped by two policemen while she was in their custody. When the matter reached the Sessions Court, the judge acquitted the policemen, stating that the prosecution had failed to prove its case. The court concluded that she had sexual intercourse while at the police station, but there was a world of difference between sexual intercourse and rape. It further stated that she was habituated of sexual intercourse and thus her consent was voluntary. When the appeal went to High Court, it convicted and sentenced the two accused and held that it was a case of passive submission. The court held that the girl felt helpless in the presence of persons in authority and inferred that her submission was as a result of fear and therefore no consent in the eyes of. However, the Supreme Court, in its final verdict, reversed the judgment and acquitted the policeman on the grounds that there were no marks of injury on the girl and girl had raised no alarm, which indicated that the alleged intercourse was a peaceful affair. This verdict led to wide-scale protest and four professors, Upendra Bakshi, Raghunath Kelkar, Lautika Sarkar, and Vasudha Dhagamwar, wrote an open letter to the then Chief Justice of India, questioning the concept of consent in the judgment. In the letter, they drew the distinction between submission and consent, which stated that consent involves submission, but the converse is not necessarily true, nor is absence of resistance necessarily indicative of consent. The letter resulted in the public outcry, and a number of feminist groups were formed. A Mumbai-based feminist group named Forum Against Oppression of Women demanded a review of judgment. It led to mobilization of women's movement, and coordinated demonstrations were held in Bombay, Delhi, Nagpur, Pune, Ahmedabad, Bangalore, and Hyderabad. Moreover, the increasing number of custodial rape cases, such as that of Ramiza B case and Maya Tyagi case, sparked the debate about the need for change in the rape laws, and this led to the legal reforms with the passing of Criminal Law Second Amendment Act 1983. The act brought about significant changes, and sections 376B, C, D were inserted in order to deal with custodial rape. Section 114A was inserted in Indian Evidence Act 1872, under which, if a girl in her testimony contends that there was no consent given by her, then the court shall presume the same, and the onus to prove that there was consent lies on the accused. The amendment further introduced Section 228A in the IPC, which dealt with the prohibition of disclosure of the identity of the victim. Also, in the coming years, the court gave some progressive decisions on rape laws and emphasized that the cases should be dealt with utmost sensitivity. The Supreme Court of India, in the case of State of Punjab versus Gurmeet Singh and others on 16th January, stated, "Rape is not merely a physical assault. It is often destructive of the whole personality of the victim. A murderer destroys the physical body of his victim. A rapist degrades the very soul of the helpless female." Further, owing to the growing criticism of the treatment of the victims in court during the cross-examination, the court was of the opinion that while every latitude should be given to the accused to test the veracity of the prosecutress and credibility of her version through cross-examination, the court must also ensure that cross-examination is not made a means of harassment or causing humiliation to the victim of the crime. But at the same time, there has been a number of disturbing judgments as well, where courts have shown their regressive and patriarchal mindset, and the accused has been acquitted on unreasonable arguments. In the case of Bhanwari, a Kumhar woman who was trained as a Sathin and worked for Women's Development Project, was heavily criticized by upper class men and ostracized for her work on various social issues which challenged orthodox practices like child marriage, and as a consequence of which she was gang raped. The court acquitted the accused, as it was of the view that it is not possible in Indian culture that a man who has taken a vow to protect his wife could have quietly watched his wife being gang raped, and further stated an upper caste man could not have defiled himself by raping a lower caste woman. Although Bhanwari Devi struggled almost all her life but never received justice, but it was because of her case that led to BIL in Supreme Court by activists from Jaipur and Delhi-based organizations. It was propagated that Bhanwari attracted the ire of her rapist solely on the basis of her work, and henceforth the court prescribed the famous Vishakha guidelines, laying down norms to protect women from sexual harassment in workplaces. Next, we come to Nirbhaya rape case in 2012. The gruesome Delhi rape case shook the whole country with the brutal gang rape of a young woman who was named Nirbhaya by media for not revealing her identity as per Section 228A, subclause 2 of IPC. She was brutally gang raped by 6 men on a bus in Delhi, and her internal organs were pulled and her private parts were mutilated in a very inhuman manner, and that caused grave injuries which ultimately annihilated her life. She was treated as an object, an article for experimentation, and prey to the pervert proclivity of the sick. The attitude, perception, the bestial proclivity, inconceivable self-obsession, and individual centralism of the six made the young lady to suffer immense trauma, and in the ultimate eventuate, the life spark that moves the bodily frame got extinguished in spite of availing all the possible treatment that the medical world could provide. This was said by the court. On 29th December 2012, she succumbed to her injuries and died. The four defendants were convicted of rape, kidnapping, murder, and destruction of evidence in September 2013 and were sentenced to death penalty, which was upheld by Supreme Court in 2017 by stating that the case clearly came within the category of rarest of the rare case. One of the accused, Ram Singh, allegedly committed suicide in Tihar jail, and the juvenile perpetrator was sentenced to 3 years of punishment in a reform home as per the provisions of Juvenile Justice Act. Now, with respect to this, as a result of all this, Justice Verma Committee provided a report. The national level demonstration and massive public outrage after the Nirbhaya case led the government to act quickly. And as a result, Justice J.S. Verma Committee was set up to suggest amendments to criminal laws. The committee made recommendations on a wide range of issues dealing with all kinds of sexual crimes. The committee recommended that the exception for marital rape should be removed and stated the relationship between the accused and complainant is not relevant to the inquiry into whether the complainant consented to the sexual activity. It made recommendations on the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Bill 2012 and criticized the existing mechanism of Internal Complaints Committee, stating that it defeated the purpose of the bill and recommended setting up of an employment tribunal. With respect to the punishments of rape, the committee was of the view that such offences need to be graded. The committee said that there are instances where the victim or survivor is still in a position from which she can, with some support from society, overcome the trauma and lead a normal life. Hence, the committee was of the opinion that the introduction of death penalty for rape may not have a deterrent effect. The committee also looked into account the views of majority of scholars, leaders of women's organizations, and other stakeholders who strongly submitted that seeking of death penalty would be a regressive step in the field of sentencing and reformation. However, they enhanced the punishment to mean the remainder for life. As a result of all of this, Criminal Amendment Act 2013 came into force. In consonance with the report given by the Justice Verma Committee, the Criminal Law Amendment Act 2013 came into force on 3rd February 2013, which introduced comprehensive changes in the Indian Penal Code 1860, Code of Criminal Procedure 1973, and Indian Evidence Act 1872. Under the Act, the most important changes were made in the definition of rape laws. Earlier, the law was restricted to only penile vaginal intercourse, but the new amendment substituted the Section 375 of IPC and widened its ambit by including any bodily penetration as rape. So, an explanation was also added in the section which defined consent as an unequivocal voluntary agreement when the women, by words, gesture, or any form of verbal or non-verbal communication, communicates willingness to participate in the specific sexual act. Also, the age of consent was raised from 16 to 18 years. Further, Section 376A to 376D were inserted with a Criminal Amendment Act 2013. 376A talked about provided intercourse by a man with his wife during separation. Whoever has sexual intercourse with his own wife who is living separately from him under a decree of separation or under any custom or usage without her consent shall be punished with imprisonment of either description or for a term which may extend to 2 years and shall also be liable to fine. 376, intercourse by public servant with women in his custody. Such intercourse is going to be punished with imprisonment of either description for a term which may extend to 5 years and shall also be liable to fine. Intercourse by superintendent of jail, remand home, etc. would also be punished with imprisonment of either description for a term which may extend to 5 years and will also be liable to fine. Intercourse by any member of the management or staff of a hospital with any women in that hospital. Here also the punishment amounts to imprisonment of either description for a term which may extend to 5 years and shall also be liable to fine. The expression hospital shall have the same meaning as explanation 3 of section 3. Now, after all of this, need for the Criminal Amendment Act 2018 also arose. Despite the progressive reforms in the anti-rape laws, the ground reality of rape cases is the same. Almost six years after the Delhi rape case, the mind-numbing Unnao and Kathua rape cases shook the entire nation. In 2017, a 17-year-old girl, minor girl, was kidnapped and raped by a former BJP MLA, Kuldeep Singh Sengar, his brother Jaydeep, and others. The girl's father was arrested in an arms case. He was allegedly beaten up in the custody and later died. Later, the victim was severely injured in a car accident, and two of her aunts died in the accident. Owing to the seriousness of the case, the apex court transferred all the cases registered in connection with the Unnao rape incident from Lucknow court to the Delhi court. Kuldeep Singh Sengar was convicted for kidnapping and raping by the Delhi High Court. The court asked him to pay 25 lakh to the victim apart from the life sentence. 2018, again, the Unnao rape incident coincided with the infamous Kathua rape case. An 8-year-old girl in Kathua, Jammu and Kashmir, was raped by 6 men for a week, after which she was killed. Since the deceased was a Muslim girl and the accused were Hindus, it thus became an issue of communal politics, because of which the accused garnered support in the name of religion. The apex court had to transfer the cases from Jammu and Kashmir to Punjab in order to ensure fair trial, and 6 of the 7 accused were convicted. It was the result of these brutal cases that led to the widespread protests that pressured the government to bring about stricter laws against such heinous crimes. Owing to this, the government passed the Criminal Amendment Act 2018. The Criminal Amendment Act brought about changes in the Indian Penal Code, Indian Evidence Act, the Code of Criminal Procedure, and protection of POCSO also, Protection of Children from Sexual Offences Act 2012. Under IPC, Section 166A, 228A, 376 were amended, and 3 new sections, 376AB, DA, and DB, were inserted. The subsection 1 of Section 376 has been amended to increase the term of punishment of rape not less than 10 years, but which may extend to imprisonment for life and shall also be liable to fine. Further, subsection 3 has been inserted, which prescribes the punishment for rape of a woman under 16 years of age, stating rigorous punishment for a term which shall not be less than 20 years, but which may extend to imprisonment for life and shall also be liable to fine. Section 376AB has been inserted after 376A, which provides for rigorous imprisonment for a term not less than 20 years, but which may extend to imprisonment for life and with fine or with death in cases where a woman who is raped is under 12 years of age. Section 376DA has been inserted after Section 376D, which deals with the punishment for gang rape and states that a woman under 16 years of age is raped by one or more persons constituting a group or have acted in furtherance of a common intention. Each of those persons shall be punished with imprisonment for life and with fine. Section 376DB has been inserted, which prescribes punishment for gang rape on women under 12 years of age, stating each of those persons shall be punished with imprisonment for life and with life or with death. But still, there is a continuing struggle for women in courts. Even after the long, painful struggle by the women's movement, which have led to making of progressive law, there have been numerous instances where the judgments show prevailing patriarchal and misogynistic mindsets followed in the courtroom. Delhi High Court, in the case of Mohammad Farooqi versus State, acquitted the accused by giving a controversial judgment which examined the concept of consent in a deeply flawed manner, stating that a feeble no by the women could mean a yes. Similarly, this shows the flaws in no means no approach taken by courts, whereby the sexual intercourse may stop after detecting a no from the other party. The issues come when the courts fail to appreciate the communication of no or establish that a feeble no may mean a yes. Thus, there is a need to shift the approach of courts and adopt a new concept of yes means yes while determining the consent in rape cases. Like in California, Governor Jerry Brown signed a bill into law and became the first US state to define yes means yes law in sexual assault cases on college campuses. There have also been cases where the rape survivors have been advised and compelled by police, courts, and family members. Madhya Pradesh High Court ordered granting bail to the person who was accused of molesting a woman on the condition that he would get a rakhi tied by her on the day of Raksha Bandhan. The Punjab and Haryana High Court granted bail to the accused in the case of Vikas Garg and others versus State of Haryana, also known as Jindal University rape case, and took a very patriarchal notion while making remarks on the character of the victim by describing her conduct as promiscuous. Over the years, the offense of rape has been an issue which is dealt by government only as a result of public outrage after new and more barbarous incidents take place. Because of this, our system still fails to provide the victims a safe and protective environment. Even though there have been progressive reforms in the laws, there are some debated issues such as marital rape, gender neutrality in rape laws, etc., as reported by the Justice Verma Committee, which need to be taken into account with immediate effect. Several cases have been brought to attention the ambiguity and inconsistency in the judgments by the courts. The judgments, such as the Faruqi case, destroy the efforts of years of reforms and take us 30 years back to the Mathura case. This reflects the deep embedded patriarchy that exists in our society. The effects of colonial mindset can still be seen in today's judgments, and the status of women in the society remains the same. There are also a number of cases which are not reported because of the fear of being humiliated by the society. Victims are harassed at every step, from police stations to the courtrooms, from the inadequate healthcare system to law enforcement system. Every step during the struggle of seeking justice adds up to the trauma of the victims. The society will live in plays a vital role in becoming a barrier in obtaining justice. And as I have explained you in this video, the rape laws, we have discussed the various rape laws in India, and the movie also talks about all of this in a quite realistic manner. Thus, the impact of the laws can never be fully realized until and unless the change comes from within the society along with the legislative reforms. That's it. Thank you.